we appear to be doing when addressing this notion of the basic structure of the Constitution is really a preserve of legal and social science scholars. It is hardly an occupation of a court of law, not to mention an apex court of law like this one. So how did we find ourselves in this process? Is because there can be no doubt that in approaching the court, the petitioners had been aggrieved by what they perceived as an imminent threat to the Constitution posed by this amendment bill. But instead, what they should have done, in my view, they would have laid down a prayer in which the alleged the fear of violation of the Constitution, and in support thereof, they were at liberty to deploy any arguments, propositions, and analytic tools to convince the court that indeed such a declaration was warranted. But instead, what we have here is a fundamental departure from a long-established tradition of invoking the jurisdiction of the High Court. The petitioners instead presented the court with a theoretical construct, a fait accompli, whose declaratory validation they sought. And unfortunately, the High Court elevated this proposition as designed by the petitioners into an issue for determination, even at a preliminary level. And later they would be joined by our colleagues at the High Court. But be that as it may, now that the applicability of the basic structure doctrine in courts has nobled into a ubiquitous inquiry, we at the Supreme Court may not, without stirring justified indignation, disregard it altogether. And so I have been compelled, just as my colleagues have been, to go into an exegesis of what then is the anatomy of this basic structure doctrine. I have asked myself whether indeed it is a doctrine, juristically speaking. I have come to the conclusion, after not just a soul searching, but serious thoughts, that what we are faced with as a basic structure doctrine is no such doctrine. Instead, it is what I consider as a school of thought, or at best, a heuristic device, which a court of law, when faced with the question as to whether a proposed constitutional amendment is of such a nature as to destroy, destabilize, or distort the constitutive authority of the Constitution, a court of law faced with such kind of question can deploy this heuristic device in its effort to answer the question. But I find no fault with this rich and diverse array of opinions, so eruditely crafted by some of our finest in the judicial system, the legal profession, academic institutions, and from far afield by way of amici curiae. And indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of a real or perceived violation of the Constitution. but to begin by seeking a declaration that there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry, first through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra-constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thirds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like. Attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on, that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that, contrary to what was decided in error, if you ask me, there is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions which are capable of withstanding any efforts from whichever quarter of abrogating it, distorting it, or fundamentally changing its equilibrium. That is the question that we should ask. And when I asked that question, I arrived at an answer in the affirmative.